It's right at 1:30. Can everyone hear me? Okay. Yeah, right at 1:30. And so I know it's been a lot of information that's been circling the web, a lot of information out there concerning the executive orders. And I know many of you all have contacted my office and reached out to others regarding some of the challenges associated with that and some of the concerns that you have regarding the executive orders. And I know there was a dear colleague letter that went across the country on, I think, Friday, if I'm not mistaken. And I know some of you all may have even read that. And I know there's a lot of, on some folks who've expressed frustration. Some folks have expressed, the lack of communication about, what the impacts that it will have on ETSU and how we're going to respond to a lot of that. But a lot of those questions right now, we don't necessarily have all of the answers. So what I did was I asked Mark Folks, who's our university counsel, to kind of just talk a little bit about what these executive orders are. And I will venture to say that, if you look at other states around us, states are making decisions regarding their DEI efforts. They're making decisions about related areas that kind of preempts any executive order or preempts any, legislation that could potentially, impact ETSU as well. But right now, as Dr. Nolan has communicated to many folks, it's just continue to work until we can figure all of this stuff out. So I know Dr. Folks doesn't have all the answers today. I knew that when we scheduled this meeting. But what we do have are the executive orders, and I wanted him to kind of talk us through a little bit of what that is and give us an opportunity to ask questions. And again, as I said, we may or may not have the answers, but at least we give a shot at it. So Mark, it's on you. Take it away.
All right. Thank you, Dr. Johnson. It's a pleasure to be here with you. I guess to the extent that one can take pleasure from such tumultuous legal situations. And I will do my best to let you know what we know. In many ways, we are still finding these things out. So first, I thought I would explain a little bit about what an executive order is and where it fits within our constitutional structure, because that is an important piece to understand what's going on, and what the likely responses will be. So, as I'm sure you all know, the president is the chief executive for the United States, and the Constitution gives the president certain authority within which to act. Executive orders is the way that the president acts. Now, for most of his actions within the domestic arena, there has to be some congressional legislation that authorizes him to act, or basically sets what the baseline rule of law is. And if he acts contrary to those statutes or contrary to his constitutional authority, then we end up in litigation if somebody decides to file a lawsuit. And I'm currently teaching a course on American constitutional law in the political science department right now. And we are actually talking about Article 2 right now, which is the powers of the president. I told them that we are going to learn a lot about the president's Article 2 powers over the course of the next year. So that's kind of how it fits. There is a realm within which the president gets to direct certain actions and certain conduct for federal employees. And one of the examples that I tend to use is with the U.S. attorney. The U.S., a lot of people in the national media often talk about the Justice Department being independent and it needs to be independent. But the reality of it is, the attorneys, the U.S. attorney is not independent of the president. He is a member of the executive branch, and the president is the chief. So the president can direct certain actions to be taken. And some of those actions, most recently, I think the one that's gotten some of the most recent media play is the orders to dismiss a criminal case brought against Mayor, is it Eric Adams of New York City, which had been instituted under the Biden administration. And certain assistants within that New York office have quit because they feel obligated to present the case. Well, it's the president has the authority to make that type of direction for the reasons that he has. He is the chief law enforcement officer for the United States as the head of the executive branch. So there is, in a lot of ways, very, very broad power vested in the presidency. Now, but again, what the president does is constrained by the Constitution and by laws passed by Congress. And then if those two are in conflict, ultimately that's something that the United States Supreme Court or the federal courts will have to resolve. And that's kind of the situation that President Trump's flurry of orders is putting the country in. So I will start. And as Dr. Johnson mentioned, I don't know all of the answers. We are still learning things every day. It's a flurry of executive orders that are coming out. It's kind of difficult to keep up with when you have other things to do. But I'll go through some of the ones that are perhaps most likely to have an impact on our campus. And I will start with the executive order that is designed to end government DEI programs that have been put in place. Now, and this basically, it does what it says it does. Now, it is often important to look at the actual terms of these diversity, equity, and inclusion programs, as we have seen happen in Tennessee in recent years. When they have gone after diversity, equity, and inclusion, it was really what we saw in the divisive concept statute, which was one version of diversity, equity, and inclusion. And some of those things within that statute, we weren't actually doing at ETSU. Other campuses in Tennessee may or may not have, but a lot of them really we weren't doing here. So that statute did not have a major impact on our campus. Now, when it comes to the federal government's role, they've issued the order to end these programs, which it refers to as discrimination preferences. Now, the most important thing that I would like to impress upon you is what this ends is preferences and programs designed to grant preferences. So, what happened over our country's history, and, without going into too deeply into it, coming out of the Civil War, we amended our Constitution to add the 14th Amendment. The 14th Amendment was designed basically to level the playing field, make sure that freed slaves and their children were brought into society and received all of the rights that a citizen of the United States was supposed to receive. The period of Reconstruction that we went through was designed to implement that. Of course, if you even have a passing recollection or knowledge of our history, it didn't exactly work out that way. And we go fast forward, we had civil rights enacted immediately following the Civil War. We went through that period, then we get to the 60s, we end up with more civil rights acts being passed. And it was in the 60s that basically the view was we need to do something affirmative because our efforts to level the playing field never worked. And we know that's pretty much how it went. So that's where a lot of the affirmative action programs started and have existed in various forms to different extents all the way up until we arrive today. Now, originally, that was just about making affirmative steps to ensure that minorities were being given a chance. And that was seen in recruitment efforts, affirmative steps to be sure that you were interviewing minority candidates, things of that nature were put in place. In some places, they became actual preferences. And, higher education dealt with this quite a bit over the years. We had a number of decisions from the United States Supreme Court that were even saying, yes, race can be a factor. And the struggle with those decisions has been how do we make race a factor without, going to a quota system? Quota systems have kind of always been thought to be at least legally suspect, because if you have a quota, you might pass over one minority in favor of another minority or in favor of a member of the majority based purely on race. That struggle sort of continued. It played out a lot in higher education. It kind of came to a head most recently in the case of Students for Fair Admission, which was actually a case in which various minority groups were pitted against each other. Harvard was discriminating against Asian students, and I think in favor of African American students and Hispanic students. And it was creating these disparities where you had applicants who had very, very high qualifications were being passed over essentially because of their race in order to admit somebody of a different race. So in that case, the US Supreme Court basically issued a ruling that should effectively end that. And again, there's a string of cases. I'm not going to go into them, but it was always sort of a struggle. Early on, it was like, we've got to take these remedial steps to fix the harm that has existed before. And then as those cases were decided, one of the issues came to be, at what point do we end remediation? Then this is the court's thinking, because if it's remedial, it's not supposed to be permanent. And then we come out, work our way all the way up to Students for Fair Admission, and they basically say you shouldn't be doing this at all. It's illegal. It's been a long time, since the 60s. We need to end it. And that was part of the movement that was otherwise going on. Again, we've seen it play out in Tennessee, in other states, at the federal government, these movements by other groups saying, we shouldn't be drawing distinctions on this basis of race, creed, color, religion, national origin. Those things are supposed to be illegal. We shouldn't do it against anybody. And that's where we ended up. So in the current administration has really made it its own emphasis to follow that law and implement it. So that's how we got to the executive order President Trump issued. Again, it has a very specific definition of what diversity, equity, and inclusion programs are. For the most part, again, from what I've seen, and it's times like these where I learn more and more about what we're actually doing across campus. But from my review of the executive order, I don't think it's going to have a major impact on us, because a lot of the things that it was after we already weren't doing. I know in hiring, we have had certification of applicant pools. As far as I'm aware, that was done only to make sure minority applicants, veteran applicants, disabled applicants were given interviews to get a chance. I'm not aware of anybody ever actually being hired on the basis of their race. I could be wrong. I can only operate within the scope of the information that I have. So there are things, and this office, going back to my predecessor, had always advised human resources, you can't hire somebody based on race. We can do some recruitment efforts. We can do some affirmative steps to make sure people get an opportunity for an interview, but we can't hire them or deny them based on race. It has to be based on their qualifications. So those aspects, especially given the laws that our General Assembly has already put in place, really, I don't expect a huge impact. Um, so, but we probably will have to make some changes. The thing in this realm that makes it a little more clear is that the United States Attorney has issued a memo that indicates they plan to take affirmative legal action against what they call the quote worst offenders in the use of these DEI programs. And what are they going to do in that realm? Well, they plan to have the Department of Justice Civil Rights Division actually start filing discrimination lawsuits, which could be filed, anytime there's a racial preference for one race, you've got a whole litany of other races. It's not just, the white-black dichotomy really doesn't work in this country anymore because our Hispanic population has grown, our Asian population has grown. We have a litany of other minority groups that are out there. And this movement, as it is explained, is basically to make sure none of those groups are being discriminated against. So they have advised that the Department of Justice is going to seek out the worst offenders and they will be filing civil rights lawsuits. So again, I'm advising the administration, as I always do, what we have to do to follow the law. And I know some things are being looked at where we need to make adjustments to bring ourselves in compliance with this new guidance, as we've done in many other areas over the past, we had some guidance in the previous Trump administration that got changed under the Biden administration. Now it's going back here. We just have to make adjustments based on what the administration is telling us that it plans to do. So in light of the fact that this is a priority for the administration and that they intend to pursue civil rights litigation, the university will be looking at, where do we need to make adjustments? I don't know if any decisions have been made final, but those are things that we will see when the administration decides where those adjustments need to be made. Very often it may be title changes. It may be slight or maybe even large adjustments in mission of various departments and divisions. We have to look at those things because what's going to, one of the things in this case you look at is if somebody comes to our website, what are they going to see that's going to make them dig a little further? So we might make some of those adjustments that way and then make the necessary adjustments in our operations to bring it in compliance with this new version of the law. Again, I do not have full knowledge, and let me back up. I don't know that those decisions have been made. I know we are looking at what we have to do to comply with the law. And again, I do not expect this, excuse me, I do not expect this executive order to have a major impact because we've already made a lot of adjustments based on state law. And some of these things we already were avoiding just because of the way we didn't like the way it looked. We didn't like operating that way. So that's my impression. Um, and so we'll see where that goes. I don't know that the U.S. Attorney has filed a lawsuit yet. So we have to wait and see how that goes. Now, that's as to general operations. I don't think, as far as our admissions go, the case that sort of sparked this was about Harvard. Harvard is operating at full capacity. Harvard has to have a way to pick the group of students that are going to be its next class. We are not operating at full capacity. And in fact, from what I understand, we would like to grow by a couple thousand students. So we're not in a position where we have to have these programs with respect to admissions. We have, my understanding in my working with the foundation, we have never had race-based scholarships. We have, even when donors wanted it, we always tried to work to make those scholarships broadly applicable and not race determinative. So as far as I am currently aware, we should not see a big impact in that regard. The place where we may see a big impact is research and government contracts. So a lot of the programs that we have had in place, if you were wanting to get a government contract, and we have, I don't know the dollar figure, but I know we are a big player in government contracts, particularly in the healthcare field, maybe in some others. Previous government contracts would include provisions that you had to at least certify that you were doing you had certain diversity, equity, and inclusion programs, or that you were taking certain diversity, equity, and inclusion steps. What we are seeing now is that this administration is probably going to look at those things, take those things out of government contracts, and they may unilaterally amend government contracts requiring us to certify that we are not doing those types of things. And again, my general impression is we're not doing a whole lot of it. I don't expect that we're going to have to end a whole lot of programs. But we are going to be in a position where in government contracts, we may have to certify to the federal government that we are not doing any of those things. And when those contracts come in, the administration will have to review that contract and say, okay, what are we certifying? And go back and double check, are we doing any of these things? And depending on what they put in the amended contract, we may have to make adjustments to keep the contract. And those contracts do impact a pretty good portion of our employees. So we want to do what we can to keep those contracts coming. So I have not seen it impact any of our contracts yet. I just know that has been, the affirmative steps were a part of government programs. Now they're probably going to, at the very least, take that out of our contracts. We may see them take affirmative steps the other way, where we have to certify that we're not doing them. So we've got to wait and see on those. And need to back up a little bit here, I think, because I didn't explain when I talked about executive orders at the beginning. Most of, if not all of these executive orders are orders, not to us directly. The president orders the executive agencies. So he sets the policy direction and gives the policy explanation. And then in the executive order, it has instructions for the agencies. And the vast majority of these, that where I've read them, it says, we're most concerned about the Department of Education, probably. It says to the Department of Education, we're going to eliminate this affirmative action or these diversity, equity, and inclusion programs, you conduct a review, and then when you're finished with that review, issue guidance to whoever is impacted. So there have been some guidance letters put out. What we received during COVID was we just started receiving amendments to our contracts where we had to deal with mandatory vaccinations, we had to deal with masking and stuff like that. That's what the Biden administration did during COVID, and that may have started under the first Trump administration. They just send us amendments to contracts. All of those things should be routed through my office. I have not seen any of them yet. That is where we will see any changes to our government contracts. The other thing is grant funding. We know that the government is looking at any grant programs. We will see changes in grant requirements. Again, they may have attached a diversity, equity, and inclusion requirement to a grant. We will probably see something come back that relieves us from that obligation and puts us just at blanket, no discrimination sort of order. Or they may send us something, now the grant is conditioned on you affirmatively saying that you're not doing these things. When those grant adjustments start to be sent out, then we will have to look at those and make whatever adjustments we need on specific grants. Now, we have received word where we had, I think, at least one grant where the grant itself was for a study that had a diversity, equity, and inclusion component in it. And we received notice that that grant was just being terminated. So when those things happen, if the funding is gone, we still have options. Can we keep doing the work without the funding is the first step? Or, do we have internal funding? Can we find grant funding elsewhere? So when we learn those things, I know with this first grant coming in, that has kind of been the approach that we have seen, is that immediately, do we need the funding to keep doing the research? If not, we can keep doing the research. Can we find alternative sources for the research? If the research is still lawful, we can still keep doing the research. There is also the possibility that we do have a right to appeal those decisions, and we may, in certain circumstances, try an appeal that says the diversity and equity and inclusion component was a minor piece. We can continue this study without it, and through the appeals process, try to save some of that grant funding. So that's kind of where we are on the diversity, equity, and inclusion. We will find out about contracts probably on an independent basis, as we did during COVID, and the same thing with grants. We will get a notice with respect to an individual grant, and at that point, we will look at it and see, can we make adjustments? What's the impact? It's basically impossible for me to know how broad that could potentially be. It depends on how, truly aggressive the administration is going to be. We have already seen in some other areas some back steps. We've seen some lawsuits, which is, another potential as whether or not the state of Tennessee wants to challenge any deprivation of grant funding on our behalf. Many of these executive orders have already been challenged in court, the courts have already issued stays. So and that's why I told my constitutional law students, we're going to learn a lot about executive power over the next year. Some of the things President Trump has done, probably going to be upheld by the courts. Some of them may be stayed, and a stay may last for a couple of years. essentially rendering it ineffective. And others may be just flat out invalidated. So depending on how any litigation comes out, then again, we have to figure out, do we need to make any adjustments? Do we need to plan for what's going to follow that? So that's what I can tell you about diversity, equity, and inclusion. Again, generally, I think it will have a minimal impact on this campus based on what I know of how we have operated. I think for the most part, we will be able to make adjustments. So we keep doing most of the work that we're doing. Grant funding and contracts is the issue where we are perhaps most at risk. And that's just going to come down to an individual assessment of the grants and the contracts to see what requirements have been put in place. So I will move next to another one I've already received some questions about. And so some of you, I've given advice on this that may have been passed out. And this is the, oops, I'm looking at the wrong one. The immigration order, which takes, basically two prongs: increased enforcement, which is mostly going on at the border. The government has pretty broad authority within 200 miles of the border. We are not within 200 miles of the border. But they still have authority to operate. Now, we have, and the question I usually get is, what about ICE agents coming on campus? We deal with ICE agents on a somewhat regular basis. We have an Office of International Programs. That's how our international students get here. Those students come legally on a visa, but the Immigration and Customs Enforcement has a right to come in and conduct an audit. So we are used to those types of things. Are they going to show up on our campus looking for illegal alien students? We don't know. I would not expect that to happen. What do we do if that happens? Well, first of all, the question I get is often phrased in, what's the university going to do to protect these people? And for better or worse, the answer is nothing. We are not in a position to protect illegal immigrants from immigration law enforcement by the federal government. Doing so at any level, including an individual level, is a federal offense. It's a crime. You could be charged with a felony. So if you know illegal immigrants and you decide, I'm going to hide them in my house, if federal authorities find you doing that in an attempt to prevent enforcement of the immigration laws, that's a crime. So we cannot do that. What we can do, and what I've advised the university to do, is we're going to follow the law. And federal law enforcement, they know about FERPA. They know about state confidentiality laws for student information. I know this. I checked. The FBI's website actually has a guidance document that it gives to its agents for what they can and can't do. I haven't checked for one from ICE. I would assume that they have one too, because this is guidance from the Department of Justice. They should all be receiving the same level of guidance. So if an ICE officer comes to our campus, the response should be, under these circumstances, the same as it would have been before these circumstances. And the response is, we're not allowed to give you student information without a court order or a subpoena. The exception being directory information. So if they come, just like anybody else, if they call, I guess records or admission or whoever they call, and they say, I need to know if this student, and they provide some information, is enrolled. We can say, yes, they're enrolled. If they come to campus and say, I need you to tell me what this student's class schedule is and where they will be, that information is confidential. They cannot have it without a court order or a subpoena, and that is pursuant to federal law. And federal law enforcement officers, there are some exceptions that they are aware about. And again, this does not change anything in what we have done. This is what I have said consistently for my 5 years here. They have to follow federal law. If they want the information beyond directory information, they have to have a court order or a subpoena. They can't just flash a badge and say, give me this information. So that's just what the law is. To the same extent that we will cooperate with their enforcement of immigration laws, to the extent that we are required to do so, we are going to follow the law on FERPA and other student confidentiality protections. So, that's just a straightforward issue. We're going to follow the law in all respects. So the other thing that, again, this is my understanding, if they came and asked us to identify, even if they have a court order or a subpoena, and they say, we need you to identify all of the illegal immigrants who are enrolled at ETSU, my understanding is that we really aren't going to be able to do it because we don't check a box that says, are you illegal or not illegal? We just gather what bare bones information we have to have in order to admit a student. And it's entirely possible with some students who are DACA recipients that they were basically raised in Johnson City, graduated from Science Hill High School, enrolled in ETSU, and if they're paying tuition cash, we don't have any reason to have a lot more information on them, and we're not going to know if they're here legally or illegally. It's not a question that we generally ask. So that's what I can tell you about the impact of the immigration arm. If ICE wants to come, they have every authority, just like any other law enforcement officer, to come on our campus. If they want to go into sensitive areas like classrooms and things, we're generally going to say, if you're going to go in our classrooms, you need a warrant or you need to have pretty good justification for going into those more sensitive areas. But just being on campus, presenting themselves in my office at the front desk, going to admissions, going to the Dean of Students office, going to those general offices, they're allowed to do that. And there's really nothing we can do to prevent it. It would be illegal for us to do so. So we have to follow those laws. Again, whether or not they come is probably going to be dependent upon whether they have reason to believe that we have a large number of illegal immigrant students. And if we don't know that, I don't know how the federal government would know that. My impression is that we don't. When you generally see raids, several years ago, there was one that happened in Morristown. I think it was at a meat packing plant or something. Well, the federal government had reason to believe that that operation employed a large number of illegal immigrants. So they conducted a raid. They don't typically conduct raids to find individuals. And I know many years ago when I worked in Memphis, they conducted a raid of it was probably the largest locally owned chain of Mexican restaurants. For however they found out, they had reason to believe that those restaurants were all employing illegal immigrants. They went in and conducted a raid on all of them in one day, and that restaurant chain, as I recall, was effectively shut down for a few days until they could restaff. But they generally have to have a reason to believe that there is something going on before they come in. Their resources are limited, like every other government agency. They're not generally going to come after individuals. Right now, they have stated that they are looking for criminals. They are criminal um, illegal immigrants, and they've said their focus is on the border. Um, that gives them a lot of work to do before they could worry about a handful of students who may be enrolled here. I don't expect it to happen. Um, could I be surprised? That's certainly a possibility because, like I said, I don't know that we even know how many students we have who fall within those categories. The ones we know about are the ones who come through international programs and have student visas. So um, that's what I can tell you about the immigration order. As a related corollary to that, there is the birthright citizenship order. That one's been pretty controversial, and it's already been stayed by 4 different courts. So nobody is losing their birthright citizenship. Um, what would be the impact on ETSU? Well, there's none directly, but if that order survives and the change in the law is viewed retroactively, we could see some people who thought they were citizens wake up one morning and find out um, that they are native, that they are, sorry, Chastity posted a comment in the chat that you can all look at that um, distracted me. We could see an impact only down the line from birthright citizenship if it is made retroactive. Again, what's going to be the impact of that? We don't know. Congress at some point, depending on, if President Trump's position prevails, the court's going to have to render a decision. That decision might tell us what happens. If that decision doesn't tell us what happens, Congress will probably have to tell us what happens, or individuals who lose their citizenship might have to file lawsuits. So I don't, as I've said, 4 courts have stayed that executive order. That litigation will probably last at least 2 years. It may last the full extent of President Trump's term. Constitutional litigation doesn't move like a bullet train. I've been asked my thoughts on it. I've reviewed it. I've read some commentaries on both sides, including this morning. I do see a narrow window where his order could be legally justifiable. Do I think it will be? I don't know. Do I think it should be? I don't know about that either. But I read the argument, and I say this only because a lot of people on the news and social media and whatever, and even at least one of the 4 courts are just absolutely adamant that this is unconstitutional. There are some legal scholars who point out that there is a very fine line distinction between what this executive order does and existing case law. There was a case from the 1890s that dealt with a Chinese child born to Chinese nationals who were legal permanent residents in the United States. And in that case, the U.S. Supreme Court said that child has citizenship by birth in the United States to lawfully resident parents. The distinction here is they're only seeking to apply it to children of illegal immigrants. So there is a sliver in which the courts could sustain the order when it's fully briefed and fully litigated. But I think, again, for an impact on us, that will be a while. Now, Chastity's comment in the chat brought up the impact on Native American students who are tribal members. Tribal members are treated differently, and I think we either by treaty or by statute have been granted and recognized as full U.S. citizens. So I don't think that the executive order is going to apply to them. Um, but potential, I mean, it's always a potential. I mean, the US Congress has authority from the Constitution to denaturalize anybody. They generally don't do it, but they could. Um, but Native American students are, or anybody who is a tribal member is generally treated differently. And that's by treaty with the tribes, and I think it's also by statute. They are recognized generally as independent nations operating within the United States. So while Chastity makes a valid point, I don't think this executive order is going to have that impact. I could be proven wrong. Um, so the next one, and I'm happy to answer questions at any time. Otherwise, I'm just sort of working through the ones that I have identified. Um, there's an executive order on defending women. It's called Defending Women from Gender Ideology. And basically, it's the one dealing with transgendered, mostly student athletes, I think, but it may have a broader impact than that. Um, but I don't, again, the impact on our campus is likely to be minimal because our state has already passed a law that says transgender students cannot, or transgendered women, if I get that wrong, forgive me, transgendered women can't play women's sports. Our legislature has already said that. As far as I'm aware, we haven't had any even before that. It hasn't been an issue on this campus. The other place we may see an impact with respect to transgender people generally is in access to bathrooms and locker rooms. There had been some guidance coming out of, I think it was the Department of Labor under the Biden administration, and there was one Supreme Court case that where we got into not being able to discriminate in employment based on gender identity. That case from the Supreme Court, according to the Supreme Court, was supposed to be limited to its facts, but the Biden administration relied on it in extending those rights more broadly. And that's where we got into having to deal potentially with bathrooms, with locker rooms, with other spaces like that. It may be, dorm room assignments as well. We have had some issues with dorm rooms, but we've been able to manage those effectively, either by making sure that the people in the room were fine with it or by making room adjustments. That may be harder now as our housing is completely full. So how are they going to enforce this with all of them? And I think Bethany Dye has added some comments there, which are on point. The big enforcement mechanism that the federal government has is federal dollars. And they have very broad authority to attach requirements to federal dollars. And it relates literally to I tell my students, it's one of my most hated cases in constitutional law. And that was one that some of you may remember. I grew up during this era, is when they started attaching federal highway dollars to the legal drinking age. When I was in high school in Tennessee, the legal drinking age, I think, was 18 or 19. I graduate high school and think, yeah, one of the big things about getting older is now I'm going to be able to go out with my buddies and legally have a beer. And then they started attaching, if you don't raise it to 21, we're going to keep 5% of your highway dollars. And that case went all the way up to the United States Supreme Court. They adopted a test that they put in place. And in that context, The U.S. Supreme Court said it was fine because it was not unduly coercive to withhold 5% of federal highway funds. So I had to delay my legal beer drinking until I was 21, much to my chagrin. So, yes, anytime they do these things, it's about federal dollars. Now, the federal government is also not known for batting 1,000. For those of you who follow baseball, they're not right all the time, even in what they do on an individual program basis. I read in the news yesterday that there was a program that was designed, and I don't know if this is true. I'm citing it as a hypothetical because I don't know if it was true, but I did see it reported. I didn't really dig into it. There was a program that was designed to help, I think, students with disabilities transition from high school to the workforce. The allegation is that the Trump administration terminated the program merely because it used the word transition. So how they're ferreting a lot of these things out that they are terminating is by searching for words, and they are searching for the word transition. So there's always the risk in any of these things that we get caught up in one of these types of mistakes. But again, for the individual programs, if it's a funding issue, it's going to be a grant, it's going to be a contract. We will have to deal with those issues on an individual basis. Again, on the transgender issue, I don't know that we're doing a lot in that space because of what's already happened under state law. Our state, and it's currently being litigated, you may know, has already made transition surgeries for minors illegal. That's currently being litigated. So right now, nobody should be doing it because that would be very, very legally risky while that's being litigated. So I don't know how much we're doing on it. I think there are some comments going up identifying some of those things. And what I would just advise those people, if you know of one of these things, the best thing to do is, I'm here to answer your questions. Reach out to me by phone, shoot me an email. I will look at these individual things more specifically to address them. It's just that a lot of this guidance is still coming out that we're going to, we'll have to make adjustments. There was a question about the centers on campus. At this point, I haven't seen anything that directly impacts our Pride Center, our Women and Gender Resource Center, or our Multicultural Center.
Can I speak this? So that on Friday, there was a letter that specifically came out from the secretary of the Office of Civil Rights from the Department of Education. You can look at Inside Higher Education. A lot of them have sort of summarized the article, but the letter specifically further extends that the affirmative action policy that was shut down by the Supreme Court now extends to special programs, student life, things such as cultural centers. She put the ad there, things such as cultural centers, special graduations on campuses, and campuses have 14 days to comply. And so because we have a multicultural center, as well as a special graduation for that center, we have a Pride Center and we have a Lavender graduation, those seem to be included in what that new I guess advice or whatever you can call it came out on Friday. And so I was wondering, and it says that they have 14 days to comply to that, or that individuals can file complaints. So if someone sees that this is happening on campus, that we have a multicultural center and that we're going to have these graduations in May, would they be able to file a complaint with the Office of Civil Rights? And then our Office of Equity and Inclusion, how would that fall under the extension of that.
Okay, so I appreciate you bringing that to my attention. I had not seen that. I was out of the office most of the day on Friday
Okay.
through yesterday. Got back today. I'm assuming Chastity's link was to it, and I have just printed that
Okay.
because we will need to discuss those things with the president. I'll look at what they've said. And then that's one of those things, like I said before, I mean, these developments are happening
Yes, are fast.
at a rapid pace.
Yes.
Please, any of you who are operating in this space, Dr. Brooks, Dr. Foster, others, I know Dr. Johnson does, as soon as you receive something like this, please email it to me. And I was out of the office and my email inbox fills up pretty quickly. So I may have, and I'm playing catch up. So but as soon as I get up to speed on that, I will get with the president and all those concerned, Dr. Johnson, the provost, if
Well,
necessary.
let me step in a moment, Mark. Mark, what she's referring to is that dear colleague letter. We did get a copy at the university. I think it was Friday. Dr. Nolan, in our cabinet meeting on yesterday, that was a part of our discussion, and Dr. Nolan is going to meet with you and have some discussion. I have a meeting with him tomorrow, and we're going to be discussing some of those because these things in that dear colleague letter were very pointed, and we do, unlike those executive orders that you referenced. Some of the things that were in those executive orders we don't do. But in this dear colleagues letter, there are some things there that we definitely do, such as the multicultural celebration, the Pride Center, celebration, and some of the other things. So that letter is a little bit more pointed, and that yes, in the letter there was 14-day response time, and there were some threats in there that you would not receive federal dollars if we did not comply. So those are some discussions for those folks who are here. Those are discussions that we're going to be having this week to try to figure out what does that really mean specifically for us, and what provisions do we need to make, what adjustments we need to make to address this. So, Mark, you are going to be brought into this. We were made aware that you were out on yesterday, but you definitely are brought into this.
Yes, well, thank you. I figured, as soon as I saw Dr. Foster's note pop up there, I'm like, okay, this is going to be something that I'm going to have to look at. And I appreciate all of those that you have commented, including Ms. Wang giving me the article on Inside Higher Education, which I printed. I will be reviewing all of that. We will figure out what we have to do. A lot of times, it will depend. The job of a lawyer is often in drawing fine line distinctions. The problem is usually exclusion. And there's a question on there, Dr. Foster added about historically Black fraternities. You could make that even broader to historically Black colleges, which
They're next, probably.
I graduated from Tennessee State, so as an alum, I have been closely following the developments in Nashville already. And I have my own reasons for being interested in that part. So again, we're going to be looking at all of these things. When you hear about these, and I see a comment from the director of I guess that's the Women's and Gender Resource Center. We're going to get you some guidance. If you need it with anything specifically as to your department or program, be sure to bring that to my attention or run it up the chain to make sure that Dr. Johnson's aware of it and get it on. It needs to be either on my list of things or the president's list of things, so that when I meet with him and we go through these, we can see if they comply or not. A lot of times it involves, and what we've done in the past as this movement has started, is go through specifically what is the stated mission of the program? How does the program operate? We got to look down and get granular, as they say, and figure out how these things are how we are currently operating. That's the first question we will look at. What are we currently doing? Does that violate the order? If it does, can we adjust to save as much of the program as we can? That's kind of how we go through this. We only have to eliminate the parts that are specifically rendered illegal or that are specifically tied to federal funding. Otherwise, we can continue doing stuff. The big issue in discrimination is exclusion or preferences. So I don't know. My impression is the Multicultural Center doesn't exclude anybody. If we're not excluding people, that's one thing that we're going to look at. The university generally does not give preferences anyway. So as long as we don't have programs or things giving preferences, we may be okay. But I've got to look at this dear colleague letter. And then the question is going to be, have they overstepped their lawful bounds? And then I'll have to advise the university what to do. And then ultimately, we're represented by the Tennessee Attorney General's office. I'm involved on a meeting with them every week on Thursdays. So we talk about a lot of things with them about a lot of these things on a weekly basis. This letter came out on a Friday. I'm sure it's going to be a subject of our meeting this Thursday evening. So that's what I can tell you. Those are the big points that I'm aware of. I think we're running a little bit out of time again.
Yeah, so let me step in here, Mark. I want to thank you for providing us the information, because I know oftentimes we may not be responding in a timely manner to get you what you need. So right now, I think it was a good time to just kind of talk about that. I know there's going to be a lot of ongoing discussions. I was kind of moving through, looking at some of the chats that's there. Yeah, we're going to try to definitely those areas that report to equity and inclusion, and even some of the other areas. I'm going to make sure that you're involved in the process. As Mark indicated, with many executive orders and oftentimes with the letters, the dear colleague letter, there are specific things that we can't do, but there are a lot of things that we can do. And I want to focus on the things that we can do. So in response, as I have more conversations with Mark, more conversation with Dr. Nolan, the goal is to figure out what we can do. I know I've been meeting with Bethany, I've been meeting with several different folks regarding the centers on campus, and we've talked about name changes and we've talked about other things. So if those are the kinds of adjustments that we need to make, then definitely you're going to be involved in that process, because I think you may know more about what would be the most appropriate name and those kind of things. But obviously, I think there may be we may have to dig a little bit deeper than just name changes. So I will keep you in the loop on those kinds of things. The other thing I would say is that this Zoom today is being recorded. I know that we have just over 40 people here, and I know there are some of your colleagues who may want to see this. I'm going to make sure that we make this available. We'll put it on our website, we'll put it in a newsletter, and we may end up sending it to you all directly who were part of this today. And this way you can share it with your colleagues, because I think it's very important that we stay in dialogue about what's happening, because it's going to impact all of us at East Tennessee State University. I want to make sure that we have processes in place that includes all of our students. I don't think we've had any intentions on exclusion, but the perception is that we have. And so, as we work through some of this, I want to make sure that, our success at ETSU is based on all of our students, moving forward. And so I want to thank you all again for joining in today. If you have any additional questions, I'm sure Mark is open to email questions to him. Also, I'm open to email questions to me as well. So just send those, questions. If I don't have the answer, I'll reach out to Mark or others and try to get as much information as I can, and then I'll respond back to you. I think Mark just put his email address in the chat. Obviously, you all know mine, johnsonkay@etsu.edu. And I wish you all a great day, and hang in there. We're going to try to do our best to make sure we can continue to educate all of our students that the university serves. So thank you.